Thank you for joining us for CSBA's Legal Update. I'm Elaine Yama-Garcia, Interim General Counsel at CSBA. In this video series, we are discussing life after Janus, the decision by the U.S. Supreme Court that has transformed public sector employment relations and collective bargaining by declaring mandatory agency fees to be unconstitutional. This monumental decision prompted labor unions throughout California to lobby legislators to obtain more protective and union-friendly laws. Today's discussion will cover some of the issues that districts and county offices of education are now facing based on the impact of the Supreme Court's ruling and related California legislation. So, with us today is my colleague, Mike Ambrose, staff attorney here at CSBA. Thanks, Mike, for joining us.
Thanks, Elaine.
He's been following this case very closely. It is also with great pleasure that we welcome our guest panelist, Karen Rezendes. Thank you, Karen, for joining us today.
Thank you.
Karen is the managing partner of Lozano Smith with 29 years of experience representing public education agencies. Her areas of legal expertise include advising board members, administrators, in-house counsel, and personnel commission members about governance and legal compliance issues. Examples include compliance with the Brown Act, Public Records Act, Employment and Labor Laws, the Affordable Care Act, and Equal Opportunity Laws. Karen also advises public agency employers regarding best practices for encouraging positive and effective labor relations, employee contracts, evaluation, workplace investigations, and discipline. As a statewide expert in employee-employer relations, she has negotiated hundreds of agreements with labor associations on behalf of public education agencies throughout the state of California. Previously, Karen was a school administrator, hearing officer, and a pro tem Superior Court judge. So thank you and welcome again, Karen. So in the past, we have had other videos and information that we have distributed from CSBA. So we've kind of gone through the Janus case, what that meant when it first came out, the legislation, but we will reiterate that for our audience today. But I think that with this audio series, I believe that it's real important to address some of the concerns that school districts are now facing today, and what kind of questions they've been and comments that they have received either from other organizations, employee organizations or employees, or the general public with regard to what this law means and what it's requiring. So I just, and how to answer those questions, right?
Right.
So there are 4 areas that I kind of thought that would be of interest for the school districts that we have been hearing, and Karen, I've spoken with you before about what's been out there in the field with respect to our school board members. And the 4 areas that we're going to cover today is reconciliation and revocation of agency fee payers. And then we'll talk about indemnification, what that really means, and how to address that. The Public Records Act, I know a lot of school districts have been receiving a lot of these requests from various agencies. And then we'll touch on the First Amendment right to free speech, board members' First Amendment right to free speech, and how AB 866 is consistent or inconsistent with that constitutional right. So Mike, why don't you start us off by just giving us a quick summary of Janus, so just as a reminder and for those folks who are joining us first.
Yeah, we've all read this opinion, and I think sometimes we get caught up in the Supreme Court decisions being the most important thing, but it would be understandable if board members still don't have a firm understanding of what exactly the court did in Janus. So I want to take just a couple minutes to explain it again. We have done, Elaine, you and Troy did the Facebook Live. The day that the decision came down, we recorded a webcast afterwards and talked more about the decision. Today we're going to talk a lot more about sort of the impacts of legislation and some of the questions that have come up around districts. But just as a quick refresher on what happened in Janus versus AFSCME, Supreme Court came down on June 27th and changed what had been the law for the last 4 decades or so after Abood versus Detroit Board of Education. And the law in California and I think 22 other states had been that if you were a non-member of your union, if you decided not to join your union, you did not have to pay what was considered the political portion of your dues. And that was the money that would have gone to contributions to campaigns and that type of thing. You still had to pay an agency fee, or what was sometimes called a fair share fee, which went largely towards collective bargaining and affording that was provided on behalf of all employees. And so for California teachers and public employees, they had to pay that agency fee if they were non-members. They're still represented by their union as they are today, but they were non-members of their union. Now, after the court's decision in Janus, if you are a non-member of your union, you do not owe any fees. There is no longer an agency fee that you have to pay. Essentially, the court came down and said that agency fees, compelled agency fees, are political speech as well. Collective bargaining deals with issues with pensions, with salaries, with these things that, at least in the court, the majority view of the court, was political speech as well, and that compelling payment of agency fees was compelled political speech in violation of the First Amendment. And so what the law is now is that if you are a non-member of a union, you do not need to pay any fees into your union. That now means that there is at least immediately somewhat less money for unions, because those people who were non-members are no longer paying their agency fee. That stopped on June 27th. They're no longer required to pay their agency fee. They could choose to, but they cannot be compelled to.
Right.
What this means going forward in terms of union membership and how people are going to respond to the new incentives put in place by the court remains to be seen. And we're going to talk a lot today about SB 866, the new legislation that was also passed on June 27th, the same day as the court's decision, and then all the questions that arise of sort of the life after Janus.
Yeah. Okay, great. So you mentioned the SB 866, and I'll just quickly run through that. Of course, before the trailer bill, which is what we refer to as SB 866, which was in the trailer bill that was signed by the governor approximately 2 hours after Janus came out. What this legislation that was previously implemented prior to that was AB 119, and that really talked about the union right to attend employee orientations. So that was there. And then when AB 866 came out, it expanded that to include the non-disclosure of the time or the date or the place where those orientations are going to be taking place. And then there was AB 285, which mandated that public employers not deter or discourage the public employee from becoming or remaining a member of the union. That was also expanded in AB 866, which applied to applicants and added some other language with regard to the representation of union membership. SB 866 also added mass communications, some issues with regard to mass communications, and when the district or employer wants to put out those mass communications. Mike, you want to go ahead and talk about that?
Sure. So specifically when a public employer is putting out a mass communication about joining the union and about the union itself, then there's now a meet and confer process as part of 866, where the public employer needs to meet with the union about the text of what's being put out there. And the written communication may be a published document. It could also be a written out speech. So for board members, that may be particularly relevant. If the meet and confer process, if there's not an agreement on what can be said, there's then in the law a process for publishing multiple documents from the union and from the public employer. But there's an opportunity here certainly to find common ground on the message of what can be put out by boards here.
Great. And then there was also a section that was added with regard to the employee authorizations.
Sure. So as a public employer, if you have an employee come to you and say, I'd like to stop being a member of the union, or I told my union that I no longer want to be part of them, you need to stop deducting my dues. Under 866, that sets up a process for this, and that employee needs to go through their union, and then the union will tell the public employer, in this case the school district, that this employee is no longer a union member. You should stop deducting an agency fee due or stop deducting their dues altogether. Also within 866, essentially the union has to or can certify that their list of who is a member and a non-member is correct. And then if there's a dispute about that, the union indemnifies the district against harm that may be caused by that. And we'll get a little more into sort of the specifics there. Right. If there is a dispute about the list, or if the union does not want to certify that their list is correct, then there's an opportunity for the district, and we recommend that the district should look over that list, compare their list of who is a member and a non-member to the unions, and find agreement on then who should be having their fees, their dues deducted, and who shouldn't.
Right. There's a lot going on here, and I wanted to remind our audience that for the CSBA Gamut subscribers, that we have put out our board policy 4140 that sets out the requirements for the board in policy, and that has been provided to our members, subscribers. It was provided on July 15th, so make sure you look out for that.
4140 has been updated both with explanation of Janus and then with explanation of 866 and all this legislation that's come up. It's got both the sample board policy and then increased notes explaining to board members sort of guidance on what all this means and then pitfalls they need to look out for.
Right, right. So let's talk about reconciliation. The lists of agency fee payers and the due fees payers, and what the district has in their records and what the unions have in their records, and making sure that that's reconciled. But I know that there's been some issues in the field, and Karen, what have you been seeing out there?
So when Janus dropped, it dropped at the end of a payroll period, at the end of June. So it was very difficult for districts to pivot and automatically stop collecting agency fees immediately on a dime. So most districts are implementing the Janus decision in the month of July for this last July payroll period. And because a lot of employees are either 10-month or 11-month employees, some of this won't be implemented until September, fully implemented in terms of payroll changes. So some of the issues that districts have been calling about and questioning have to do with any sort of disagreements or issues in terms of the various lists of employees. So everyone in a union is a bargaining unit member, regardless of whether or not they're a union member. So everyone who is a unit member can be a union member, or they can be a non-union member. Regardless of that differentiation, they're all represented by the union for purposes of collective bargaining. So for those folks that have been described as agency fee or fair share or fee payers, districts have to stop collecting those fees. And so where the disputes are happening is the district may have a list of people that they have identified as agency fee payers, and the union may have a different list. And so there may be discrepancies. One of our districts had discrepancies that went back many years. I think one was 14 or 15 years, where the union said these people should be dues paying union members, and the district said we have no record of that. They should be agency fee payers, and we're going to stop collecting. What SB 866 says is, district, you have a few options in that scenario where there's a disagreement between the union and the district about who's who, which is which. And so what SB 866 says is that, district, you have to rely on the union's representation regarding who's who. So in the situation where there's a discrepancy, the onus is on the district to communicate that discrepancy to the union, have conversations with them, document that discrepancy, and the union's responsibility is either to certify that their data, the union's data, is valid and the district must rely on it, or if there still is a dispute, then the district's responsibility is to show the district those authorization forms to prove that an employee has affirmatively opted into being a union member. Now, where issues are coming up, and this is life after Janus, and everything isn't fully settled, where the issues are really coming up is what happens in the gray area situation where the union won't certify, but they also are uncomfortable providing examples of these or the actual authorizations for individual employees. How do you proceed? If the union provides the certification that the data that they have is accurate and the district relies upon it, the district's entitled to be indemnified if any one of those employees sues the district. If the union doesn't certify and the district isn't able to see the actual authorization form, there's some unclear direction in terms of where we go from here. 866 doesn't tell us what the next steps will be in that circumstance. So those are the kinds of issues. So for board members, if you're facing those sorts of reconciliation issues, the best thing to do is to work through your HR administration and your superintendent to defer employees back, because another aspect of 866, as we talked about, is you don't want to be in a situation where you're encouraging someone or discouraging someone from their right to participate or not participate in a union.
Right, right. So usually, what does indemnification mean? How has it been interpreted by the law?
Sure. So board members are probably familiar with a variety of different ways that term is used. So for public employees and board members, if they're acting in the course and scope of their job, there's government code language that provides that the school district as an organization or the county office as an organization will defend and indemnify employees or board members who are acting in the scope of their work. This legislation, SB 866, isn't as specific as that law. You may also be familiar with contract language. In a number of collective bargaining agreements, there will be a hold harmless provision relating to everything to do with union rights. So the collection of union dues, agency fees in the past, religious objectors in the past. And so that language is going to be controlling in a lot of situations. But what SB 866 does is it just refers to indemnification. It doesn't refer to a broader scope of rights to protect a district from acting upon a union's direction, meaning it doesn't provide for the defense, it doesn't use that term, and it doesn't use the term hold harmless.
Right.
So both of those terms are missing in this legislation, so there's a lack of clarity in terms of what SB 866 means, and given that lack of clarity, school board members, school administrators really need to work with their legal counsel, look at their collective bargaining agreements, and make judgment calls on where they want to fall. Because if an employee disagrees with a union's direction to the district's obligated to comply with it ultimately.
Right.
The district is going to be the first party to be sued. And so they're going to still have to defend themselves in any sort of a proceeding, and it's going to be up to the district ultimately to try to recover to get indemnification or payback from the union if they relied upon the union's direction.
And I also have understood that there are some unions at this time attempting to negotiate with the districts on particular language in order to define what that means, what indemnification would mean. Have you seen some of that language that's been floating around, and how should board members look at that? And I'm assuming to be very cautious, but yeah, what have you seen?
So what you're trying to do and what we're trying to do is help board members spot issues so that they can anticipate them and be aware of potential concerns and issues going forward in liability. So what we're starting to see is proposals from our labor partners that try to refine what's in SB 866. So that refinement could be either positive for the district or negative for the district. So board members, administrators need to very carefully look at any proposals to modify that word indemnification, anything that refers to hold harmless or defense, because the kinds of proposals we're seeing right now are beneficial to the associations in terms of limiting their obligation and their liability and their cost, and moving that liability and costs onto the district's shoulders, where, of course, we don't think that's the right place for it to reside.
Right.
This is the stereotypical lawyer advice here, but I think districts should talk with their legal counsel, especially if they're getting proposals for definitions of indemnification and limitations on what sort of indemnification or what liability the unions will cover in this process. Then I think it's an important time to bring in your counsel and make sure that the district is comfortable with whatever risk they may be taking on in that process of the certified and the authentication of who's a member of the union and who's a non-member.
Exactly right.
This also, though, sort of separate from where districts need to be thinking about this and their risk right now, is a place where we're involved. So as we're filming this, there's still discussions about potential cleanup language to 866. And I think indemnification is possibly an area that will get additional language in the text of the law itself. We don't know that for sure, but at the very least, CSBA will be continuing to provide updates to any changes to the law and is continuing to advocate for changes to the law and clarification that takes some of the risk away from the districts here. Who are just trying to process
to better
this.
define our responsibilities and the requirements that are put on our members, our school board members, as well as the districts and the county offices of education and the administrators. So that is really important, because I think that as CSBA moves forward in their legislative efforts, we are definitely looking at pursuing some cleanup language. So thanks for reminding me of that, and also or us of that, and letting our audience know as well. So let's move on from indemnification. I want to talk about the Public Records Act requests that have been going around. I know that a lot of districts and county offices of education have been receiving requests for just various information regarding whether it's the employer's the employees' names, their just personal information, maybe their personal email, or not personal email, but their district or county office email addresses, things like that. So can you talk a little bit about what else is what's going on in the field, but also maybe start with just backing up a little bit and talking just generally what the Public Records Act requests, the limitations are, and the requests, the responses, sorry.
Okay. So the California Public Records Act is found in the Government Code at 6250 is the section where it begins. And in the past, voters have actually voted to make the California Public Records Act the right to access information that public agencies maintain, a constitutional right to have access. So all school districts, all county offices, all public agencies for that matter, are responsible for making public, upon a valid Public Records Act request, all information that they maintain about the entity's business. There are exemptions from that, but you have to start with the general rule that everything is disclosable, and then you have to narrow it down from there. There are certain privileges and certain exemptions for certain types of records. Over the last few years, those exemptions and privileges have been very limited by the courts. So the courts take a very expansive view of what's disclosable.
Right.
So what's happening now is that you have different organizations trying to get information from school districts because they want to use that information for a political purpose related to being in a union or not being in a union, especially after the Janus case. And so like whenever a law drops, a new law drops, there's a lot of opinions out there regarding what the law means and what has to be disclosed and what doesn't have to be disclosed. So every labor group that works with school districts has a legal opinion on this issue, and probably every one of the major law firms that represents public educational agencies has a legal opinion on this. Ours is called a toolkit. It's on our website. But bottom line, what you need to do is you need to really look at the specific facts in your district. So one of the big topics of dispute right now has to do with emails, whether or not work emails are disclosable under the Public Records Act. So labor associations are arguing that there's a privacy right, and when you balance the privacy right of the employee compared to the right of the public to know that information, that the right of the employee trumps the right of the public, and that sort of information shouldn't be disclosed. That's one argument. Another argument that's being made is the First Amendment right to freedom of association. When a Public Records Act request is seeking information that identifies an individual as a member of a particular organization, that right to association is potentially going to be infringed upon if the disclosure is based on their connection to that particular association. That's another argument that's being made. What sort of undermines a lot of those legal arguments is the fact that a lot of school districts and county offices are very accessible to their communities, to their parents, to their student population. So they post email addresses, phone numbers, work locations on their various websites, whether it's a school site or a school board or school district website. And so once that happens, to make an argument that there's a privacy right or some other right makes it very difficult. So districts throughout the state are either taking on this issue by really looking at those privacy rights and the unique facts in their district and declining to respond to those requests, arguing privilege or exemption. And other districts are saying, you know, in our district, the context is that that information is readily available. So to now try to claw back that information and say it's not available to the public would be difficult for us to do. The other aspect of this is if that information ends up being provided or ends up being accessible through the website, unions are also proposing that districts negotiate filters to their email systems and do other sorts of things to limit the access of these other outside entities with political viewpoints from having access, direct access through those emails to district employees. And so that will be another issue that we will all have to work through. Again, as school board members, you don't want to be on the razor's edge of defining which side of this issue you want to be on, because being on the razor's edge means you're going to spend a lot of money on people like us. And so I think you'd rather spend your money on kids. Yeah. So it's just important to be very cognizant of all of these potential issues that are coming up with regard to the PRA request.
And just to sort of throw a bone to school boards here and recognize the difficulty is you're getting CPRA requests and you have a duty under the law to provide all the information that is disclosable that has to be provided. At the same time, you're trying to keep great labor relations in this time that is particularly fraught, and you want to be responsive to your labor, your labor group's concerns. And you're hearing from, we've seen memos from labor groups saying that you don't need to provide this information. Certainly from the outside groups that are requesting this information, they're making arguments that all of this is disclosable. And so boards can feel trapped in the middle of this, and that's that opportunity to be really clear about what you have to provide, and then your reasoning for not providing. If you're not going to, check your website to make sure what's already being provided. And then to keep these lines of communication and have these conversations both with your legal counsel and then if you want to with your labor unions as well. Karen, can I ask on this, is any of this negotiable if boards are hearing that they have to negotiate this? Is that right?
So that's another hot topic and a good issue in terms of us discussing it. So many associations have issued demands to bargain on the topic of compliance with the California Public Records Act. So the easiest answer in terms of all the things that we've been talking about is school districts don't have an obligation to negotiate whether or not to comply with clear law, right? So in this case, the California Public Records Act, a tested law, a constitutional law, districts have to comply, and they can't negotiate to delay compliance or following timelines. So they can't negotiate to comply or not to comply. Then the second thing that districts and county offices are facing are requests to bargain the effects of Janus, the effects of complying with Public Records Act's requests. That's where the topic of filters and other sorts of limitations on access to union members or access to employees is coming up. So with the effects analysis, it's the standard analysis of when you have to bargain the effects of something that a district has no discretion with regard to, like compliance with the Public Records Act. That's when there's a multi-part test in terms of what's negotiable, in terms of effects and impacts, and what's not. So in the first sort of review of those effect negotiations analyses, the district isn't obligated to delay compliance with the Public Records Act in order to negotiate the effects. So that's the first thing school board members need to know. The second thing is the union has an obligation and the district has an obligation to clarify and seek clarification from the union regarding what is a potential effect. The union has to clarify what they believe a natural impact or effect would be for complying with the Public Records Act or complying with Janus. If they're able to, there may be some negotiable impacts. But if they're not able to, then those impacts are not negotiable. So it's going to depend on your constructive conversations, clarifying those requests as you work with your associations. The other thing to keep in mind related to that negotiations aspect is every collective bargaining agreement is totally different. They're all the result of hopefully good faith bargaining that results in a good contract for both parties. In many contracts, there's something called a severability clause, and all that means, it's usually in the back of collective bargaining agreements,
Yeah.
that this whole contract is valid even if one piece of it has been determined to not be valid. You kind of excise that piece that's bad, get rid of it. The rest of the contract's still good. So many collective bargaining agreements have that language in it, so there's no obligation to rush to reopen negotiations if it's not the right timing for your district in terms of term.
Right.
The other thing is, if you don't have that language, there's likely to be a lot of other provisions in your collective bargaining agreement that deal with agency fees, religious objectors, collection of dues, the authorization for the collection of dues. All of those topics, with the exception of the Janus related and AB 66, could be negotiable, and it may be in the district's interest to start a dialogue on those topics immediately rather than wait to the next round of reopeners or full contract.
Yeah.
Things to be thinking about.
Yeah, and it sounds like it will be unique to each district, and making sure that they're weighing their risks or issues so that they're making the right decisions for their community and for their district. So that's good. I'd like to go into our discussion with regard to the free speech and SB 866 and how they meet or not, or that maybe they're inconsistent or consistent. But I think that with 866 and the deter and the discourage language and our board members as being public officials, how is that, how do you reconcile that? And I know that some of our board members have had, they've been questioning that. You have to think about the fact that, although it's not defined in 866, but clearly as public officials, they should be able to discuss issues of public interest, but with 866, making sure that they keep that in mind. So what have you been hearing out there with regard to that?
Well, the Supreme Court, when it discussed Janus, it was entirely focused on free speech, right? The First Amendment right to free speech. Right. So it would be very much in conflict with the Janus case to imagine that school board members' speech is going to be impaired to the extent that it interferes with school board members' right to free speech. 866 creates some question marks, but before 866 even came to pass, there were laws already in place that have been found to be consistent with law. So let me just sort of give you a background on the issue of free speech as it relates to board members and collective bargaining. So prior to 866, the EERA, the Educational Employment Relations Act, talks about what employers can and can't do and say as it relates to union representatives. So one of the basic principles of collective bargaining in California is that employers, including school board members, can't engage in conduct that interferes with the exclusive representation of unit members, the exclusive representation of employees in the district. So what does that mean? They can't interfere in that representation in terms of their communications. So how it's been interpreted is that school board members and administrators can't engage in two types of speech. One is they can't communicate to unit members, to employees, that if they agree to something or if they do something, that they will get some sort of a great benefit from it.
Yeah, right.
If they're going to have those kinds of conversations, it needs to be in the context of collective bargaining, right? We're proposing this increase, we need this language change. That all can be done, but it has to be done with the exclusive representative, and it has to be done in the context of labor negotiations. So one, board members can't promise a benefit to employees directly without working directly through their exclusive representative, whoever they've designated as their labor rep. So that's one thing. The other thing they can't do is they can't threaten a harm. They can't say, if you don't accept our last proposal, we're going to have to lay off all of these brand new teachers. So that's threatening a potential harm. That's been the law for a long time. So they can't promise a benefit, they can't threaten a harm. That's been in place for a long time. They can't undermine the exclusive representative's authority when it comes to collective bargaining. They need to work directly with those representatives. So what SB 866 did was it provided sort of a bullet point under that existing system for communications, and what it says is that we're going to give you a specific example that would be unlawful. And the specific example has to do with mass communications. Well, then they define mass communications to say multiple employees. So the three of us are multiple people, right? So how big is multiple employees? It could be more than one, right? So first it defines mass communications as multiple employees. That's one thing it does. And then two, it defines mass communication very broadly. It can be a written communication, it can be a recording that's transmitted, so I would interpret that to also mean like a video recording at a board meeting, or anything that's scripted. So if there's a script that is intended to be communicated to multiple employees, then those are the communications that they're referring to when they say mass communications. So what we've been advising districts, because it's challenging, we don't want to interfere with the public's right to know. We don't want to interfere with board members and their constituency relationships in terms of how they feel politically and how they communicate. At the same time as we want to advise districts in such a way that protects the district from liability. So a lot of districts are appointing point persons that are very knowledgeable about this very recent law and having information be funneled through them. On the other hand, if a board member wants to speak, particularly on a topic, then that makes it a little bit more complicated, but they can certainly get advice and maybe some support and parameters from legal counsel about how to do that without running afoul of any of these new laws. And then the other question, which is an unanswerable question, is whether or not some of these laws are constitutional when it comes to public officers and agents.
Absolutely. I think that that's a concern that has come to focus with respect to these laws and our board members and their individual free speech rights as well. It does get a little sticky when there's at a board meeting and there's no intention of discussing certain issues, but it is at a public board meeting, and it doesn't necessarily mean that there's some intention that they're going to be discussing solely about the 866 issues, or Janus issues, but it could come up. And so it does become a little bit sticky. So yes, I think that getting the attorney's advice and at least and getting that point person assigned at the district is really good advice as well.
Elaine, just one more aspect to it. When we were talking about what the law was before 866, one of the things that cases that have since interpreted the law, not the 866 portion, but the free speech portion have really focused on, is whether or not the information is also factual. So when information is factual, let's say you're at a board member, someone during public comments makes a comment for or against unions. To choose to comment or not comment might be the first thing you're thinking, but also if board members do choose to comment or administrators do choose to comment, to just be cognizant of those two words, deter or discourage. So if you're communicating, just keep in mind, if you're encouraging or discouraging people to join or to leave the union, that's when you're on a little bit of thin ice. And then finally, don't forget all the people that are considered administrators in your district that also have a voice, whether it's at a staff meeting or in a staff staff room or at a PTA meeting or at the school carnival. They need to be aware that they shouldn't be expressing views to multiple employees that would be considered discouraging or deterring employees from either participating or not participating. So being able to communicate with your administrators to have them have their necessary direction and talking points so they don't create liability for the district is also very important.
Yeah, and I think just on that point, creating a point person in the district that can answer questions about Janus and about union membership is, I think, a convenient way to allow administrators and board members to focus on teaching and running good schools and these things. It's not meant to be a gag order. It's just that with new legislation coming down right as Janus passes, there are sort of more complications to what we say about union membership right now that we're still navigating, and having a person at the district who heads up that communication. It just makes it easier for everyone involved.
Right. So, yeah, that brings back our, how CSBA is going to pursue the cleanup language.
Yes.
Some proposals anyway for that cleanup language, and I think that that's really important because we do need that better defined and clarified so that it doesn't, step on board member or administrators' free speech rights as we move forward, kind of navigating through these requirements. So we talked about that. We talked about our newly revised board policy that is available with the Gamut subscription. And, we also talked about the various writings and videos that are on our website. So it's gathered there. We had a lot of writings that we have shared. So if you're interested in that and this video as well as some additional writings will be available on our website. So just as a reminder, I think that, and as we're learning here, everything is, we're kind of learning as we go at this point and at this stage. It is new, it's just a month out, right? So it's been a little complicated. I know that there are a lot of questions and a lot of issues out there. So, and they're kind of being thrown our way and in every direction from a lot of different sources. So, just to be with varying perspectives as well. So just being very cautious, school districts and county offices of education, they're all unique and they'll be giving unique answers or their own unique responses. And so just making sure that those judgment calls are being made with respect to reviewing your collective bargaining agreement, reviewing your policies, and knowing the potential risks and costs to the district if there may be some as well. So just making sure that you're looking at all those things.
Yeah, I think board members should, if this is a high stress issue for them, should try to lower that stress a little bit. They don't need to know all the changes in the law and all the intricacies of the Janus opinion. Mm-hmm. Really, what is most helpful for them is to be able to, as we've said, issue spot here, that when it is a mass communication or a written communication to multiple employees about union membership, then take a step back and ask your legal counsel or other board members what you need to do within the new laws. Mm-hmm. If you have employees asking you about Janus or whether or not they should join a union, and it brings up that union membership and that advice again there, that's another place to take a step back and make sure that you are in line with the newly created laws.
Right.
Generally speaking, your running of the district and you're providing an excellent education for kids is going to remain the same, and board members can keep operating their day-to-day just as they've been doing here.
That's right. That's right.
I do think I'll put another plug out for board policy 4140. It's got sort of a lot of simple language and guidance in there that's updated that's really helpful after 866 and the new legislation.
Yeah. So is there anything else going on out there, Karen, that Lozano Smith has been working on? Anything else you'd like to add?
Sure. Sort of following in CSBA's footsteps, we've put out quite a bit of material that's accessible through our website. We have a webinar podcast style description of a lot of what we talked about today. We also have a toolkit that's very valuable that has checklists and additional information. And as has been emphasized, just the importance of individualizing next steps to your district and your unique circumstances can't be emphasized enough.
Right.
Very important.
So I think that's it for us today. We want to thank our viewers for spending the last hour with us, as well as our presenters for the valuable insight. Karen, thank you for being available today to contribute your wisdom to help our members better understand these very important and current issues. You may contact us if you have any questions via our email addresses that are posted here. We welcome your suggestions for future topics. So if you have a great idea for us, please email us at legal@csba.org. And thank you again for joining us today.